The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 27th of April, 2016, are currently trading with gold at $1,244.98 an ounce, silver $17.20 an ounce, Texas crude $42.64 a barrel, and Bitcoin is currently at about 457 U.S. currency. Today in history, the year 1909, the Sultan of Turkey, Abdülhamid II, is overthrown by the Sultan's military counter-coup, which was in response to the Young Turks' coup. His brother Rashad Effendi was then proclaimed as Sultan Mehmed V, the fall of Abdülhamid II. Today in history. In recent news, Dennis Hastert, former House Speaker, was sentenced to 15 months in prison and ordered to pay $250,000 today and 2 years of supervised release once he finished his prison term. The fine is for a victim's hush money case, which was uncovered by the FBI, where he was accused of sexually abusing young boys as a teacher in Illinois. Hastert did admit to Judge Thomas M. Durkin in open court that he abused at least one child. The primary accuser in a sexual abuse case, who had received $1.7 million from Hastert, has also sued Hastert for the remaining $1.8 million he was promised. The president of Venezuela, Nicolas Maduro, announced on his regular presidential broadcast that in a desperate attempt to save electricity, the public sector or government employees, who make up a third of the country's workforce, will work Monday and Tuesday and have the rest of the week off. This 5-day weekend is being implemented in order to save as much electricity as possible. The shortage has resulted from a drought the country has been going through since Venezuela's electricity primarily comes from hydroelectric plants. They're banking on the rainy season, which is expected shortly, to save the country's electric shortage. Forced blackouts lasting 4 hours at the minimum have been imposed across much of the country, putting the country's scarce food supplies in restaurants and markets at risk of spoiling. For more than 12 hours after the declaration, rioters, as could be expected, went on a spree against businesses and even attacked the headquarters of the government's power company, Corpo Elec. If significant rainfall does not arrive within a few weeks, much of Venezuela will be at risk of a near total blackout. Venezuela's economy is projected to shrink 8% this year, with inflation running at a whopping 720%, according to the International Monetary Fund. Though the effects of socialism on people are not funny, I can't help but ask what socialists used for light before they used candles. Apparently it was electricity. This was your lowdown for April 27, 2016.
My remedy today came in a box just like they say.
Okay, we are back. Randy Kelton back, Rule Radio, and we're talking to Mark in Louisiana. And first thing you need is a good evaluation, a good accounting of everything that's been paid. And I can assure you're going to have a terrible time getting it. How old is this note?
It's not that old. We got about 6 years. I have to double check. I know it's not that long, 6-7 years.
Okay. To your knowledge, have they changed servicers?
Well, when we first got it was through this Interlink mortgage, and in less than 2 weeks, we're dealing with Wells Fargo.
Has it been Wells Fargo ever since?
Yes.
Okay, that helps because generally a servicer can only provide you with accounting for the amount of time that they've been servicing the loan. And so when you do a debt validation, and this might be proper for a debt validation letter, if you have reason to believe that they're charging you incorrectly or adding inappropriate charges, you might do a debt validation letter under the Fair Debt Collections Practices Act and ask them to validate the debt. Well, they will give you an accounting. Most of the times when I get an accounting, it's not readable. They give you an accounting that has terms that are in the form of acronyms that you don't know what the acronyms mean, so you don't know what any of the numbers mean. But if you get a true accounting where you can tell what everything is, it'll only go back until this servicer took over the note. And that's always a problem. However, once you get the accounting, then you can go back and ask for invoicing supporting the amounts charged. If they can't produce the invoices, then you go in to strike the whole amounts that they charged.
Right.
So I'm sure they're going to claim escrow amounts for other things, taxes, they're going to do a song and dance about what they're actually charging for. So you want the validation of all of the charges. That should get you started.
Okay. Make them prove it up.
Yeah. And okay, if you get the validation and it doesn't support the fees, then you might want to send a tort letter. Do a calculation on how much you project. You can do since it's 6 years, you can look at the average increase over time, and then you can project that across the full term of the note and say, based on this mean increase over 30 years, you can expect it to increase this amount. And since they fail to support any of these increases, you can imply an intent to defraud you of this ultimate amount. When you claim fraud, you don't claim the amount you were actually defrauded of. You claim the amount you would have been defrauded of had their plan went to fruition. So you do a projection across the face of the note and establish how much it appears they intended to defraud you of. But you don't sue for that amount. You sue for treble. So this should give you a pretty good number to throw at them. You put that claim in a tort letter. The courts say they don't want you to use the court as the first remedy. They want you to use the court as a last resort. So they ask you to exercise civil remedy. And the only civil remedy that they ask you to exercise is to give notice and opportunity. Notice of harm and opportunity to cure. And that's what a tort letter is. You have harmed me by fraud, and your intent to harm was this amount. Therefore, based on your fraud, I would be defrauded over the face of the note for this amount. Since it's fraud, it would require triple damages. I've been harmed by this amount. Make me wholly be sued. And if you use the spreadsheet and plug the numbers into the spreadsheet, you can give them a calculation to the penny. If you go into court and sue them, they're going to work on whittling down the amount that you claim you owe. But in the real world you and I live in, at the end of the day, the jury's only going to remember one number. And that's the number you walked in the door with.
Right.
So you run a calculation. You don't do like the Republic of Texas does and say, you owe me $11 trillion for that traffic ticket. You go in there and say, you owe me $253,198.51. And then they say, well, you just made that number up. Actually, I didn't make that number up. Here are my calculations. You can challenge any one of those calculations you want to. And if you prove up any one of those fees, well, I'll deduct that from the calculation and we'll recalculate. But at the end of the day, the only one the jury's going to remember is the number you walked in with. And they know that. So, gives you good bargaining position. This is the thing I'm finding out. If you get foreclosed on improperly, these courts are so corrupt. They're going to rule against you no matter what. They've been bought and paid for. Okay, maybe they haven't. But it behooves you to conduct yourself as if they are. So what we do is another consideration, another calculation. How much is it going to cost them to fight you?
Exactly.
Yeah, does it cost you $600 to $800 an hour to write pleadings?
No.
So, and
it may cost a little bit. It's not going to cost that much.
And what happens if you start bar grieving them in judicial conduct, complaining the judge?
Oh yes, that's definitely on my list.
Oh, these guys so hate pro se's, and they don't hate pro se's because pro se's write stupid pleadings. They like that part. They hate pro se's because every once in a while they come across the pro se from hell. The pro se who knows how to sting them good, and there's nothing they can do about it.
You said send them a letter, qualified written request. Where can I get an example of that?
Okay, a qualified written request is a notice of an accounting error. There is no magic special format for that. It's merely a letter claiming an accounting error and demanding that they correct the error.
Oh, okay.
So I do have one. but it may be too devious for you. It is a debt validation letter, qualified written request, and notice of rescission. I take it you're up to date on your mortgage payments.
Oh yes, that's
so. Okay, so you might want to take out the notice of rescission on the last paragraph, and I can prepare one for you, but I will need the HUD one. We can, if you want to send a debt validation, I suggest you do one with the HUD one calculations, and add in the increases in escrow, and that'll increase the amount of the calculation. And you send them the whole enchilada. And now you bring a much larger claim. I could probably get you 2 to 3 times the original principal in a claim against them. It's all about the money. So if you're interested, send me an email, randy@ruleoflawradio.com. I'll send you a list of what I need, and I'll tell you what I think I can do.
I'm going to go back and review this in the archives when it comes up, and so I'm not trying to write any of this down and remember it. My memory's, I'm getting old. So
I just talked to my mother today and wished her happy 39th birthday, and she reminded me again that I keep getting that backwards. But at 93, she tells me this memory thing, it is not going to get better. It seems to get, we lose things. But I'm going to go through the archives and double check on all the stuff that I need to do as far as all the calculations, and probably give you a email. Yeah, send me an email and I'll give you a written explanation, because that is a little complex and convoluted. And I'll cut some out of some of the documents. I may stick some numbers. I'll give you a sample of the spreadsheet I used to do that with, so you can see what I'm talking about. Okay.
I'll take this, and we'll see if we can go with it from there then.
Okay. Thank you, Mark. Okay. Now we're going to go to Erwin in Nevada. Hello, Erwin.
Hello. Can you hear me?
Yes, I can.
Yes. Okay. Thank you for taking the call. I'd like to describe a situation to you for a house in Virginia, which is a deed of trust state. I saw your video from a few years ago mentioning trying to do maybe a breach of contract and doing a quiet title, but I'll get to hopefully why Virginia is a tough state for that. But the situation is this. Okay, I'm not the original borrower. I'm shown as the owner in the county, but a Marine got the house with a VA loan in December of 2008. Okay. 9 months later, and the so-called lender was Taylor Bean Whitaker. I don't know if you're familiar with them.
Yes.
9 months later, they were shut down. They were raided by the FBI and shut down, and the head of the company went to prison for 30 years. Okay, so the Marine is going through the years, and eventually, 2012, he's transferred out of the country to an undisclosed location, couldn't make his payments anymore. He deeded the house to me. Now, the first thing I'd like to mention is that the trustee appointed was a woman lawyer. I actually got to contact her years later, and she said she doesn't remember being appointed the trustee, but she said it's very commonplace for them to be replaced, trustees that is. But one thing in the contract, it says substitute of trustee, that lender may for any reason from time to time remove trustee and appoint a successor trustee to any trustee appointed hereunder, blah, blah, blah. But it says the lender and nobody else. Now, MERS is involved in this, and the place I read this says, in law and contract, that means only the lender and no one else may appoint it. Oh, hello?
Yes, I'm still here.
Oh, I'm sorry. I heard music, so I thought we went commercial. The lender and no one...
Oh, that means we're going to break. I'm glad you heard it. I didn't. Okay, hang on. Randy Kelton, Rule of Law Radio. You kept me from falling off the cliff. Randy Kelton, Vet Pack, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you.
Okay, we are back. Randy Kelton, Vet Pack, Real Law Radio. And we're talking to Erwin in Nevada.
Right.
Okay.
Now, as I was saying, it says only the original lender supposedly can appoint a successor trustee, and she remained the trustee from 2008 until 2012 when the Marines stopped paying. So what's wrong with that picture? When 3 years after Taylor Bean and Whitaker was forced out of business. That's the first kind of shady thing.
Okay, that brings up a question. Have you secured all the documents from the county recorder's office?
Yes.
Okay.
The instances have been DAC Home Loan, followed by Recon Trust, followed by Bank of America. I actually sued them all for Fair Debt Collection Practices Act things, and I got default judgments of 2 of them.
Okay, hold on. Listen, back up.
Oh, okay.
Who was the original lender?
Taylor Dean
Whitaker. Taylor Dean Whitaker. Okay.
Dean Whitaker.
Is there an assignment in the record by Taylor Dean Whitaker or by an agent for Taylor Dean Whitaker to some other party prior to the demise of Taylor Dean Whitaker?
Taylor Dean, by the way, yeah. No, the bankruptcy people took over it, and then magically Bank of America appeared out of nowhere.
Okay, here's the deal.
Mm-hmm.
If you go into bankruptcy, you will have to turn over all of your assets to the bankruptcy trustee.
Right.
Then the bankruptcy trustee will distribute those assets to the creditors. Is there any filing in the record showing that the bankruptcy trustee for Taylor Dean Whitaker took possession of your mortgage and assigned it to some other party?
No.
Then there must be a presumption that since your mortgage didn't go to the bankruptcy trustee, that at the time Taylor Dean Whitaker went into bankruptcy, they were no longer the holder of your mortgage. And there's nothing in the record that shows who is the proper holder of the mortgage. So how does Bank of America claim to have taken possession of the property? Okay, let me qualify that question. How does Bank of America claim by the public record that it took possession of the mortgage?
Oh, I had the paperwork from there, and there's nothing definitive. They sent me like 50-odd pages, and I don't see anything there.
I'm not asking what they sent you. I'm asking what has been filed in the public record that gives them evidence of chain of title.
I had the county recorder send me everything in the record from that time on, and there's nothing.
Perfect. You did that exactly right. So if the county recorder can't find it, then whether it's filed or not, it's not properly filed. Now, Go to Nevada Property Code and look for a code that reflects Texas Property Code 13.01. Every state has this in one form or another. Otherwise, without this code, there's no reason to have a recorder. Do you already know? You know where I'm going?
I'm not certain. I live in Nevada, but the property's in Virginia. You understand that?
Oh, I'm sorry. They just you go to Virginia code.
No, I'm saying that's confusing. Yes, Virginia code. Okay.
Okay. And here's what we want to know. There is a statute in Texas that says, it's 13.001 property code, and it says, any claim against real property not properly acknowledged or proven and filed in the public record is void as to the holder. Every state I've looked at so far has a similar statute. Without it, there's no reason to have a county recorder. So it's going to exist in Virginia. So you go back to the record, and that's why I ask you, how do they make this claim by the public record? Because I don't care what they've got. If it's not in the public record, they can use it for toilet paper.
Wait a minute. Here's the thing. This is from Dave Krieger's book. I don't know if you're familiar with this. He goes state by state. In Virginia, he says, in talking to Virginia attorney Greg Breil, he mentioned that because the state's courts operate off of common law, obtaining a firm quiet title judgment will be extremely difficult. He managed to get a quiet title judgment for a couple in Fairfax County, Virginia, but fears that U.S. Bank will come in and get the deed of trust reinstated, as Virginia does not condone removal of deeds of a trust of other instruments in the land records. They just rule whether they're void or not. This would appear to indicate that a direct attack on the note would have to occur utilizing the UCC, which in and of itself also appears difficult, given Virginia's court's rulings that deeds of trust are merely evidence of a promissory note. There is no requirement for assignments or any other relative instruments to be recorded in the county land records, and he gives some case, noting that the assigner was not required to obtain the consent of anyone when the subject contract included a clause specifying free assignability, cited in Black Supra. While the majority of the legal community considers Virginia to be a title theory state, Attorney Breil considers it a lean theory state, given if the propensity is how note issues are treated by the courts. This would appear to make declaratory judgment quiet title cases a true uphill battle, as Breil thinks his quiet title action will be vacated because of the attitude of the courts. This would appear to indicate that absent arguments against the deed of trust directly in an attempt to invalidate it completely due to fraud, etc., these are a waste of time and pose a risk for sanctions, as Breil agrees that because Virginia has a larger population of government employees, the courts are pro-bank and tend to rule, not just under common law, more conservatively against homeowners who come into their venues with arguments not fully researched. So that's kind of daunting.
It does sound kind of daunting, but in the end, it really doesn't make any difference what state you're in. The courts are corrupt. Especially if you're pro se, they're going to rule against you out of hand at every turn. Okay, maybe they're not. But it behooves you to conduct yourself as if they will.
Right.
So what I'm suggesting is that we go at this from a different perspective. We go at it from the perspective that you will never win your case simply because you have the law and the facts on your side. You'll win your case if you have the politics on your side. So we're taught in school to trust the law and rely on the law. And we do that until we have an opportunity to actually try to use it, and then we find out we can't rely on the law. Politics you can rely on. So let's shift gears and go look at politics. Whether or not I can win this in the end, how much is it going to cost the other side, and how bad can I sting them? Everything is political, and all politics is local. First thing you do is you sting the lawyer. If you have someone trying to take an action against you, like a lawyer claiming that he's acting for Bank of America and claiming that Bank of America has standing to enforce this security instrument, how do you know if that's true?
Right.
He just said it. So the question becomes, what do you really know as opposed to what you presume or just accept out of hand? What you really know is this lawyer signed this document making these statements. That you know.
Right.
Whether or not they're true or not, you don't know about any of that. Whether or not this lawyer is actually an agent for that entity, you don't know that either. You just know the lawyer claimed it. So you don't have a requirement to stipulate to anything. So let's back up and start at the beginning. Sue the lawyer. Sue the lawyer for making false claims. There's no evidence in the public record that this lawyer has power of attorney for a proper holder of a security instrument. There's no evidence in the record that this lawyer's alleged principal has standing to enforce the security instrument. So the first thing you do is sue the lawyer. That's going to double, triple, or cancel his malpractice insurance. Bar grievance is bad enough, but when they get sued, that really gets ugly. Hang on. We're about to go to break. Randy Kelton Vet Pack. We'll be right back.
Reality TV, sugar, obesity, jet lag. The list of things that makes us dumber just keeps on growing. But now researchers say we can add stress to the list. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Are you always on the go and juggling multiple projects? If so, you might think that multitasking proves you're smart. But think again, all that stress might be eating your brain. A new study finds stress reduces the number of connections between neurons, which actually makes it harder for people to manage problems. Researchers at Yale University found that stressed out people have less gray matter in their prefrontal cortex. That's the part of the brain that helps us weigh conflicting ideas and regulate our emotions. So take a deep breath and chill out. It'll help keep your mind as sharp as a tack. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, yeah.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Irvin in Nevada.
Yes.
Okay, Irvin, where were we?
Yeah, okay. You mentioned suing the lawyers. The last place that got involved after the Bank of America group was Carrington Mortgage out of California. And by the way, they just got hit in Texas jointly with Wells Fargo with a $5.4 million penalty, like class action suit for fraudulent assignments, as it turns out. So they came into the picture in 2014 on this property. They threatened foreclosure immediately. I sent them a debt validation letter and a qualified written request, and they backed off. Oh, and by the way, the trustee is someplace called Atlantic Law Group. Now, in Virginia, you don't need a license to be a debt collector, but in Nevada, you do, and they were sending me letters, and I sent something to them, too, and they also backed off. So that's 2014. At some point last year, about April, I did a rescission, and I filed something, a notice of interest in real property.
Okay, hold on, rescission. Was it after a notice of acceleration?
Yes.
Did you claim a improper charge of in excess of $35?
No, I mentioned CFR 226.23, which special rules in foreclosure that if you go into foreclosure, you're allowed to rescind. And they...
Yeah, you're allowed to rescind if you can show more than $35 in improper charges. And
I didn't mention that specifically.
Okay.
But they didn't answer 20 days.
Yeah, that's down in, I think it's F or something. It's down at the bottom of that one. But okay,
right. Okay.
You can do that by using the HUD-1 settlement statement claims.
Oh, okay. I can know that.
Are you familiar with that?
I heard you mention to the other crow.
Okay.
I've heard it.
Let me explain this so that everybody listening knows what I'm talking about.
Mm-hmm.
When you sat down at the closing table and the lender brought out the HUD-1 settlement statement and it listed all of these fees on there, did the lender provide documentation to show that the fees that were charged were not otherwise forbidden to be charged by law, that they were for services actually rendered, that the services were necessary, that the amounts charged were reasonable, and that the lender did not take an undisclosed markup on the amounts charged? Did he provide that documentation?
No, they're only supposed to charge, 1% or some set percentage anyway, aren't they?
Okay, well, the 1% goes to the broker fee.
Okay.
But all those other fees. So your presumption is that since they did not validate any of those fees, that they're all bogus. They're all garbage. Now, you can be probably fairly certain that they're all not fraudulent. But I guarantee you, 1 to 2 always are. So when you tell them that all of these are fraudulent, and then you take the full amount on line 14 of the HUD-1 settlement statement, 14 column, I forget the column, A, B, C, I think it's D and E. The seller amount paid and the buyer amount paid. You combine those together because the buyer pays everything. If the seller has to pay something, that's added to the principal. So you take the full amount on the HUD-1 settlement statement and subtract it from the first payment as an overpayment. So that knocks this number off the principal for which you won't be paying interest on the next payment. Then amortize out the note the full 30 years. And with the amortization, each month your payment goes to principal and interest. When I did this for Steve Skidmore, who used to be on our show, his note went to zero at payment 240. The next 10 years he was overpaying. $115,000 note at 6% interest. He would have overpaid the note $50,043 and change.
That's 10 years. Wait a minute, 240, you mean 5 years, right? 60 months.
Yes. Wait a minute, I couldn't understand that.
I said, you mentioned 240, he should have paid it off, but it was a 30-year loan, so that would be 60 months, the last 5 years.
No, it was a $115,000 note at 6%.
Yeah.
He had $12,000 in closing costs. I subtracted the $12,000. I ran a full amortization of the entire note,
right,
where it had payment, principal, interest. So on that first payment, I deducted $12,000 from the principal as an overpayment.
Gotcha.
So the principal dropped down $12,000. That's $12,000 you're not paying interest on. Now you pay the same amount they demanded, and his paid down at payment 240 after 20 years. His went to zero. So the next 10 years you're paying everything is extra, and the calculations showed that he would pay $50,000 extra on a $116,000 note.
Yeah, with $50,000 between friends.
Yeah, and under fraud, you don't claim the amount they actually defrauded you of. You claim the amount they would have. It's only 6 years old, so they hadn't defrauded him of that much yet. But you claim how much they intended to defraud, and you claim 3 times that. So on a $116,000 note, I have a claim of $150. Tender by set-off.
I see.
Now you do the rescission and claim tender by set-off. But here you don't even have to claim anything after the Jazanowski decision.
Exactly.
So when you filed the rescission notice, did they respond to it?
They said I was trying to do some type of mortgage elimination scheme, and though they scheduled a foreclosure for June of last year, they called it off of their own volition without me doing anything. I guess because remember, I filed notices.
Okay. Did they file an opposition to rescission in the district court?
No. Nope.
It's over, Bubba. They got 20 days. Now they're subject to laches. If they allege a claim.
The actual borrower, so I'm not really entitled to that. I just like it reconveyed. I didn't take out the loan, don't forget, but I am showing it to the owner. And it's
Wait a minute. Do you have a quit claim?
Yes.
Okay. You got the claim.
Not only quick claim, I have the power of attorney from him as well. Although it's facts I'm talking.
Whoa, hold on. You have power of attorney for him. He gave you what kind of deed?
Okay, first we put it into a land trust. I was the trustee. He signed his beneficial interest to me without recording it. At some point, I regret doing this, but at some point I quit claim from the land trust to a corporation that I controlled, and then from the corporation to me, the individual. And strangely, I never got charged transfer taxes, any of those up to this day.
Okay, hold on. Are those filed in the public record?
Yes, they are.
Okay, the trust complicates things. Now you have to have a lawyer.
Well, the trust is long gone. The trust it's been in my name for a good 2 years.
Okay. Oh, I'm sorry. So it's in your name personally.
Yeah.
What I was trying to get to is the guys in the military. You can't foreclose on somebody in the military. Period.
Yeah, I saw some law that said I thought that you had to get the loan when that's only if you got the house before you went. He was already in the military. But on the other hand, there's this thing that says the VA has to foreclose anyway. That's from the Fifth Circuit. Have a law. So
okay. Well, we can't go there anyway because now you hold it. You hold the claim. Okay, but you can still adjudicate the claim.
Right.
It's just one we can't make. But you can rescind. You do have the power to rescind. You filed the rescission. They had 20 days to either initiate the rescission process or file an opposition in the federal district court.
Right.
They failed to do so. They're subject to statutory estoppel and to laches. Laches is where you have a right and you fail to adjudicate the right, and the circumstances of the other party changes. Then you're subject to laches.
Latches and just statute of limitations is a small but distinct difference, but I can't quite figure it out. I read it.
Okay, here's the deal on statute of limitations. You're not subject to it because after foreclosure, the right to rescind is reinvigorated, and there is no time limit, no statute of limitations on exercising the right to rescind.
Right.
I had a judge say the right to rescind doesn't last forever, and I corrected him. Yes, it does. After a notice of acceleration, it does. Hang on, we're about to go to break. Randy Kelton, Rule Radio, call-in number 512-646-1984. We'll be right back. Okay, we are back. Randy Kelton, Real Law Radio. We're talking to Irvin in Nevada. Irvin, have you read the Jazanowski case?
Oh, yes, definitely. Yes.
Okay, good. So it's sudden death. They had 20 days to raise their defense, and they didn't raise it. Every time, and I'm doing this in Texas, and I send my rescission is buried in a qualified written request and debt validation letter.
Yeah, I heard you, sneaky devil.
So I got about 15 pages of trash. If you look on the internet, you'll see these supposed qualified written requests prepared by people who don't know what they're talking about, that it's really just a request for discovery. A qualified written request, for those who don't know, is a claim of an accounting error and a request that it be corrected. That's what makes it a qualified written request. So these guys are putting this stuff out here asking for all this discovery. So I took all that junk discovery and I stuck it in there. After I demanded that they validate the debt and I claim an accounting error for a qualified written request and demand that they produce the note under UCC 3-501, then I put in all this junk discovery. Well, the lawyer looks at that. This is garbage. This is trash. I don't have to respond to this. The heck with that. And he throws it down. They never read the last paragraph. It says, if you fail to properly validate the debt as required by statute, consider this as a notice of rescission.
That is a good one. Well, you mentioned UCC. Let me ask you this. The UCC 9-210, I actually send them one of those, too. A statement of accounting based on collateral or the balance. And that says that they're supposed to respond within 14 days. Oh, by the way, I codified it. You're supposed to codify it with the state in question, in this case, Virginia. And they're usually the same number, but not always. Anyway, if they don't authenticate it, as in under oath, within 14 days, they lose their rights as well. So I just threw that in as well. But the rescission's been done. And a quick question that the tenants, of the 3 tenants who've been in those 4 years, they've all been harassed at some point by people coming around trying to do drive-by appraisals and telling them they're going to be thrown out. I always told them what was going on. And 2 of them said they would swear under oath they were being harassed. Do you think you could throw in something like, what is it, interference with interstate commerce, since that's my rental property there, or tortious interference because they're fooling around with the
people in this property, and now they're traumatized. They're in this property, they can't afford to move out, and they're being harassed, and now they're having to go to therapy because they're subject to this extreme mental distress.
Of emotional distress? Yeah, well, is that over the top, or could you,
No, that's not over the top. How would you feel if you're living in a house you're comfortably in, you've got a lease, you're paying your lease, and somebody comes and threatens you, telling you they're going to throw your butt out in the street?
Yeah, the last guy came and went and got his gun and sat down in his rocker and was rocking back and forth. I said, I don't really want to hear that. But
No, don't.
He went away. But
just
anyway.
Get you a sticker and say that this property protected by Smith & Wesson. That's enough.
Okay, well, that's that one. Now I have one more in Virginia. It's a completely different situation. This one, the original loan obtained in 2006 from Bank of America. The owner... pension was cut by almost $1,000 by United Airlines. She stopped paying September 2008, way over 6 years, which is, I understand, Virginia's 6 years statute of limitations. And UCC. Okay, hold on.
Statute of limitation doesn't start when you stop paying.
No, I know. They said breach. It says from breach. So to me, that either means when they accelerated.
No. Yes, when they accelerate. That's the marker.
Yeah, well, they accelerated in January of 2009 after she was 3 months behind, which is the usual case. Okay, she actually moved out of her house. She said an embarrassment in June 2009, and it sat vacant until February of 2011. She deeded it to me around that point. What we got to lose? Okay, so I put it.
Did she also quit claiming to you?
Yes. Oh, yeah. The same things before.
Perfect.
The trust.
Okay,
Perfect. Same thing. Okay. All right. So a tenant was in there from March of 2011, and nothing was ever recorded. It was always Bank of America, but Ocwen got involved. At some point, I sued. I just sent a cease and desist letter to Ocwen and to Bank of America, and Bank of America said, we've got nothing to do with this. We transferred this to Ocwen. I stupidly didn't keep that letter, but it's always been shown only Bank of America and the county records. I sued Ocwen for the FDCPA, and I got $5,000, a judgment against them, but I only collected $3,500 of it because you can overturn judgments very easy in Nevada, unfortunately. So anyway, okay, time goes by. I haven't heard boo from either of them for years. The tenant moved out in January of this year and trashed the place, caused about $7,000 damage. Well, I'm thinking about how I'm going to fix that all up, or if I'm going to, I get a foreclosure notice on January 28th, okay, from Brock and Scott, some law firm there. And the date was February 18th. So I think, well, am I going to try to fix up the property and rent it under this again? Or am I just going to do nothing and hope that they are stupid enough to foreclose? And they said they foreclosed it. They took it back. But it's still shown February 18th. All this time, it's still shown as my name in the county records. And I called the county recorder and said, what's going on? They said, until they send us certain paperwork, we can't do anything. So I don't know whether it's zombie foreclosure or they saw, because I rescinded that one too, and maybe they saw the recorded thing. It's a different county and the office, but they have not put it in their name. Now,
okay, let me make a suggestion. Yeah. Get your trust. Do you have the trust sufficiently isolated from yourselves so that it won't be considered an alter ego?
No, hold on. I did the trust way back in 2011. Once again, quit claim it to the corporation and then quit claim it to me. It's only my name.
Wait. Okay, so do you still have the trust?
No, I dissolved it. I just called it the office of that other place.
You need somebody to file a mechanics lien.
Oh.
Stick a party in between.
This one guy, yeah, no, he was saying, he said you get a master trust and another trust, and you have a breach of contract, but you have a confessed judgment, and if it's a default judgment, the judge is going to have to snoop into things. But if it's a confessed judgment and everybody agrees, he has no reason to, and then it's just deeded to the trust. But that sounded way too convoluted to me, so I didn't want to do that.
Just file a mechanics lien. Get somebody to file a mechanics lien. You traded them another property, or you engaged in something else. I have a friend here in Texas that I sold him a business that I had.
Right.
Now, we're not going to mention that I hadn't operated it in 5 years, but I still had it. I had all the equipment, and I sold it to him for $53,000. And I took a lien against his house as collateral for the payment. Because I went and checked the record, and Chase supposedly had a deed of trust, but I checked the record, had the clerk check the record, and I found no deed of trust. So I dropped in my mechanics lien. Good luck, Bubba. These guys claim they have a trustee's deed. Well, now you got to get past my mechanics lien. Oh, hold on. Wait a minute. Something to check. In Texas, is it Texas or is it, I forget where it's at. It may be Consumer Protection Laws. I think maybe Real Estate Settlement Procedures Act. Once you purchase a property, you have 30 days. No, this is Texas law. You probably have something similar in Virginia law. You have 20 days in Texas in which to file the deed of trust. In that 20 days, you are protected. If somebody else files an intervening claim, yours steps before theirs. You need to find out what that amount of time is in Virginia.
It's way more than 20. Yeah, I see what you're saying. And you're saying because they have not gotten it out of my name as yet, they're vulnerable to the mechanics lien.
Exactly.
I see.
You muddy up the works for them. And if you can put it in a third party's name, now they have an innocent party.
Ah, okay. Yeah, I do have the card. By the way, it's too bad. I mean, I looked for this in Virginia, but I didn't see one. In my state, it's NRS 598-0977, which is deceptive trade practices against seniors or people who are disabled. I'm a senior. But they don't have anything like that in Virginia. And since I'm here, the res or whatever you call it is in Virginia, so I can't get away with trying to throw that on as well because, deceptive trade practices against an older person.
I'm not familiar with Virginia law, and Virginia law is a Commonwealth.
Yeah.
So it's different than Nevada is based on Spanish law like Texas. So I'm not familiar with it, but they almost certainly have something concerning protecting seniors. You just got to find it. But you can get around all that real easy just by getting a mechanics lien in there.
Right.
If you know somebody who will file it, that you don't have to worry about them coming back and trying to screw with you, or get somebody to file it and get a backside contract that you can clear the lien with them for $10 and other considerations. Get the mechanics lien in, and it's just to throw a stopper in the works. This friend of mine we did that with, I came into the court with a challenge subject matter jurisdiction, a petition, and intervention, and the judge took one look at me. And this is, if you heard the beginning of the show, I filed criminal charges against this judge, and he hated me. So he threw me out and gave the lawyer the order to foreclose. And the lawyer, when he told me to get behind the bar, I walked out of the courtroom, and the lawyer was looking at me, and he was not happy. He got his order to foreclose and never did. They came back after the 2-year statute of limitations and tried to file for another order, and I wrote a collateral estoppel claim that there was already an order. He couldn't file another. It's done. They lost everything. Hang on, Randy Kelton, Rule of Law Radio. We'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Irvin in Nevada.
Right.
Okay, now mechanics lien. This is shyster tricks. So you just
Well,
stick a stumbling block in front of
I
it.
have
That's
something
what they
recorded
did
already,
for
the notice of interest in real property. So is that going to muddy it even more, or is there something superior to the mechanics lien in that?
Oh, notice of interest is not. That's just to preserve interest. You need an actual claim. A mechanics lien or materialman's lien or a deed of trust. I don't like filing a deed of trust behind a deed of trust. So I file a mechanics lien. Doesn't matter what it is. Just so long as it's a claim. And it goes to a calculation. This is all bean counter stuff. The lawyers are going to take this to the bean counters, and they're going to say, okay, this is what we got. We got this mechanics lien filed in there now. How much is it going to cost us to get rid of that mechanics lien? And they're going to say, man, this is a third party. Now we're not going after a deadbeat borrower. We're going after an innocent third party. That's a whole lot tougher.
But they won't foreclose, though.
You go to them. I always suggest you go to them with an offer to cure.
They say they foreclose, but
Yeah, if you fight the foreclosure, the courts are just not on your side. But if you go to them and say, I just did the rescission thing, Wells Fargo didn't respond, I filed a quiet title action, and then the lawyer called me to send me an email saying I'm representing Wells Fargo and blah, blah, blah. So I called him and I said, look, don't even answer that. If you will agree to mediate a deal with me, don't even answer that suit. Say, give me a cure amount that I can live with, and I'll flip this property. You take all the marks off the original guy's credit and clean up his credit, and we'll flip this property, and I'll get some money back to him so that he can buy something he can afford, and we will bring you a release of claim for any claims based on this loan now or in the future. We'll sell the property and extinguish the debt. Everybody wins here, and you'll come out of this with a whole lot less cost than if you had to fight me.
No wrongful foreclosure and violations to rights and mistrust and all that?
Nah, we don't need to do all we need to do is get them in a position to negotiate first. Right. And now, when they don't negotiate, then you land on that lawyer like a ton of bricks. Now, once you're in a suit with them, if you take over property, like you're taking over with a warranty deed or a quitclaim, and you lease out the property and you don't attempt to cure the default, that's equity skimming. And that's a felony. However, if you sue them claiming that they don't have a right to be paid, now you don't have to pay them. You're in litigation with them. And it's not equity skimming. And they don't want to make a deal with you. Like Wells Fargo, $167,000 claimed to be owed. We offered them $115,000. They offered to lower the amount by $900,000. And then they filed a removal to the federal court.
Yeah.
So I filed a challenge subject matter jurisdiction. The judge dismissed with prejudice. But in their pleading, they screwed up and said they weren't the creditor. So I filed a non-suit. Now they've screwed up. They've got we're not the creditor in the record, and it's non-suited, so they can't correct it. They're subject to collateral estoppel. Now I lease out the property. And guys, just take your time. You want to come back and try to foreclose again? I'll land on you like a ton of bricks. Yeah, I got collateral estoppel. Once you sue them, now
I don't know what that is.
Once you've sued them, now you can collect lease on the property and not be subject to equity skimming. And I told this lawyer, look, I will keep you in court until you get old. I got a guy in court that's been in court for 6 years over who the heck are you suit? I don't know who you are. I never entered into contract with you. Never entered into contract with your alleged principal. Prove it up. 6 years. We're still in litigation over that one.
At some point, you think they want to cut their losses, but
and that's the junk suit. The next one, I come back with the false fees suit. We do that one. And when we're done with that one, I'll come up with another one. I'll keep you guys in court till we both get old. Or make me a deal.
Gotcha. Okay. That's
we can't depend on winning in the end.
Yeah.
But if you...
and
the lender, the borrower who writes you the quitclaim, he wins because you've challenged all the claims, and then you send the debt validation letter, and you notice all the credit reporting agencies to remove all this off this guy's credit. And they don't want to be sued, so they do it. Now you've cleaned up his credit, He never gets a foreclosure on his credit. No short sale with a deficiency judgment. None of that garbage. So you've rehabilitated the borrower, and they win if you can sell the property. You know, if we take over a property and we lease it out, we give the person back some money, so they've got some money to relocate. We clean up their credit. Everybody wins here. Even the banks win if they come to the table. If they don't come to the table, they don't win. You know, you take all the time you want to. I'm going to lease this property out. I don't care. We've got to find a way. It's all in the end. It's about the money. So we've got to find a way to get in their pockets.
That email address, Randy, to get some details about this.
Randy@ruleoflawradio.com.
Okay. Right.
And I've got an evaluation that I do. I'll give you enough claims that they will never be able to adjudicate all of them.
Right. Yeah, I'm definitely interested in that. Okay, thank you very much. I did a Trinity versus Pagliaro claim in a hearing here in Las Vegas where there was we were being sued, and then we did a third-party complaint. And so the people being sued did a summary judgment, and they had a joiner with the other party. And when I said, they were lawyers for both of them, but the people weren't there. And when I said Trinity versus Pagliaro, the judge looked startled. Unless he was playing, why should he try to fool us? That he looked, I don't think he was doing an act, but he said he would take their advisement. And then 6 days later, he's issued an order where he said it looks like he'll be granting them their summary judgment, but he's waiting until June 25th for them to provide the order. So I assume, by the way, I have a tape of the trial. I got a tape. So I assume I can't do an appeal until he formally issues his order. But have you ever heard of anyone taking over 2 months when he's saying he's going to grant a summary judgment? By the way, he didn't mention in his minutes, which is what I got in the mail, he didn't mention Trinity versus Pagliaro at all. And the minutes were like 2 long paragraphs. So have you ever heard of...
Okay, you can't do anything until he rules. And right. Are there any cases in the Nevada Supreme on this issue?
You mean where the agency has to come out? Can I come out of the mouth of the agent? Sure.
Yes.
No, they're not. Not that I found is yet anyway.
Okay, because that sometimes they may wait for that. We have one. The one that's 6 years old in California, they're waiting for a Supreme Court ruling, and I think we just got it. I have it.
I had one in California where they said, hold on just a second, where they said that if you did anything differently, it was like an honest man could use the roguery. Just a second, it's coming up here. Here it is. Okay, Nation versus Trinity versus Pagliaro. It's California. Good grief, I just had it. And it's out of the appellate court of California as well. But you said so. It's important though to get one out of Nevada. I'll never get that.
No. If you get one out of the circuit, and Nevada and California in the same circuit, so that'll work.
Oh, ninth. You mean yeah? Well, I do have one of those. That's because California is the same thing, but no, not coming up for whatever reason.
Okay.
But,
while you're looking for that,
what's that?
While you're looking for that, the primary idea is not necessarily to expect to win your case in the end.
No.
It's just to create a situation to where it's more profitable for the other person to come to the table.
Oh.
Let's make a deal.
Fessler versus Rollins in California appellate. It was stated, quote, "It is axiomatic that agency cannot be established by the declarations of the agent, not under oath or in the presence of the principal."
Send me an email. I can send you a whole folder on that.
Oh, well, this last sentence is good. If the rule were otherwise, any rogue could use the name of an honest man to facilitate his roguery. I never heard the word roguery, so I said that's deficient.
I like a good turn of phrase like that.
That's out of California. But okay, I will send you an email. Thank you very much for your advice, and I'll have that over by the end of the weekend because I'm going away. But thank you very much. You do a tremendous service. Appreciate it.
Okay. Well, I'm away now. I'm down in Austin, which is my favorite place on earth. Texas has the best-looking women on earth. Austin has the best-looking women in Texas. Man has to keep his priorities straight.
Gotcha. Well, I'm happily married, but
I'm too old to chase the pretty women, but they're like fine art. You go to the art museum, and they've got all these masterpieces, and you get to admire them all you want to, but they got these guys standing around, don't do anything all day unless you get close to one of them. And they run up and they say, "Don't touch, don't touch."
Okay, Randy.
Thank you, Irvin. Now we're going to go to Gary in Oklahoma. Hello, Gary. Sorry you had to wait so long. What do you have for us?
Well, I've got chickens, and I've had them for 2 years, and I had a rooster, and I got them from a place that said that they sold only pullets. Well, one of them turned out to be a rooster, so we kept them anyway.
Yeah, I am having trouble understanding you. Are you on a headset or a Bluetooth?
No.
Okay. Do you have your head stuck inside a toilet?
No.
No, just kidding. You've got a little hollow sound. Try moving the mic a little bit further away from your mouth.
Okay. Is this a little better?
No, that's worse. That really got hollow. Try moving it closer to your mouth.
All right. Let me try another room. All right. Anyway, I own chickens, and 6 days ago, animal control came by and told us we need to get rid of the rooster. So we looked for a home, and we found one for this Sunday, but they showed up again today.
Wait a minute. This is sex discrimination. Hang on. We're about to go to break. Randy Kelton, Vet Pack, Ruby Law Radio. We're going to come back and stop them from discriminating against this chicken.
This is the Logos Radio Network.
Okay, we are back. Randy Kelton, Vet Pack, Ruby Law Radio, and we're talking to Gary in Oklahoma. Okay. Do you live in a large municipality?
It's probably about 17,000.
Okay, that's pretty small. The first question I need to ask is, how does the city have authority? I mean, that's not the right word. What did you do to be subject to their regulatory scheme? Okay, let me back up and explain why I asked that question. I suspect that Oklahoma is very similar to Texas and all the other states in that the Oklahoma Constitution authorized the legislature to write law. And they authorized the legislature to create courts as they need them. But no Constitution that I have seen has included an authorization for the legislature to delegate the authority to write law. That's why when a municipality accuses you of violating something, they accuse you of violating an ordinance, not a law. The ordinance is a corporate bylaw. It's not actually a law. So the question is how did you agree to this corporation's regulatory scheme? Are you a public employee of the corporation?
No.
Then how did you agree to abide by the corporation's bylaws?
I did not, and I explained that to them, that it was their law or their laws and ordinance to follow, not mine.
Yeah, so I don't work for you guys. This goes to subject matter jurisdiction challenge. Have you listened to the Monday night show?
Okay.
The Monday night show Eddie Craig does. And he addresses this in more serious detail. I wish I could get Harmon Taylor on. The problem with Harmon Taylor is he is so deep and so knowledgeable that he gives me a headache. It takes me 2 or 3 days to catch up with him after I do a show with him. But he is very knowledgeable on how you engage in the regulatory scheme. And in short, how to avoid it is the first thing you do is challenge subject matter jurisdiction. And it sounds like you've done that. And when I say challenge subject matter jurisdiction, that doesn't mean you go in there and say, I challenge your subject matter jurisdiction. You can do it simply by objecting to the application of the regulatory scheme. When a policeman stops me and I tell him, well, I am registered, I do have a license on the back of my vehicle, and I am authorized to operate in commerce. However, I am registered with the Department of Transportation, and you need to look up my registration. My registration gives him notice that I am a private operator, not in commerce. So that's a challenge to subject matter jurisdiction. So what did you tell the city concerning their rooster bias?
Again, I told her that was their rules to follow and not mine. And she promptly called the police. And when he showed up, I wouldn't give her my ID to write me a citation. And he promptly said, you must give that to her so that she can sign, and you will have to sign them, or I will take you to jail. And he kept bantering on like that, and I kind of ignored him and looked at her and kept, asking her for all the penal codes and ordinance codes, what numbers they were, because I wanted to document them. And when he was done bloviating, I glanced over at him and I said, is that a firearm on the side of your hip? And his face twisted up and he goes, well, yeah. And I said, is it loaded? And he says, well, what are you asking me this for? Yeah, it's loaded. I said, okay, so you're threatening me. And I said, that's aggravated assault. You're going to, arrest me and take me to a cage? So that's kidnapping as well, isn't it? And from that point on, he stood there silent. And later on, when I asked for his name and badge number, he hesitated for a long time, and then he kind of gave me a sideways look, and he told it to me. But by that time, his backup had showed up, the sergeant. And the sergeant just kind of giggled. And I was polite. I was very cordial. I wasn't a smart ass, but I was very, matter of fact about it. And,
just for the record, they really hate that.
Yeah. Well,
when they can't get you agitated, they really hate that. So wonderful.
Yeah. Well, the sergeant wasn't agitated. He was taking it in fun and laughing at the guy that I asked that to. And animal control was looking there, and her eyes just wide open, and she couldn't believe I was talking to him that way and asking questions. So finally, I submitted my ID because he kept threatening me. He's going to arrest me anyway. So,
okay, I have a question. Have you looked in Oklahoma law concerning a failure to ID?
It's only under a criminal act, and that's what I argued. I said, I have not committed a criminal act.
Okay, in Texas law, you are only required to ID after you have been arrested.
Yeah.
So there must be reasonable probable cause to believe there's been a crime, and there has to have been an actual arrest. If the officer threatened to arrest you for exercising a right, that's retaliation. It's almost always a felony.
Okay.
Either retaliation, in Texas, retaliation and obstruction are the same thing. But look up retaliation. Most of the times that they don't realize how deep the water is they're treading. And you might look under aggravated assault. When someone makes a threat, it may be a misdemeanor or Class A, B, or C misdemeanor, but when they make that threat while prominently displaying a deadly weapon, that changes everything.
Yeah.
The police are so accustomed to having that pistol on their hip and ordering people around, they forget how deep the water gets. And for the most part, people don't introduce them to how deep the water gets. So it sounds like this officer wasn't outrageous or out of hand.
No, but he was forceful.
That's what he was forceful. This is the best guy to go after. Policemen are trained in military tactics, and I was in the military. And when you're immersed in an indigenous population that could be potentially hostile, you have to take control. You have to take absolute, complete control. And they've transferred this to the police. That's what the police do. They're taught to believe that if you don't do exactly what they say, when they say, exactly how they say, their life is in danger. And we need to get that fixed. So we need to remind them that they are the servants. We are the masters. 90% of the people the police deal with are habitual criminals. And the police legitimately have to use somewhat stringent measures to control these guys. But that other 10% are us. The other 10% of the people the police deal with are 96% of the population. So how is the policeman to tell when he's not dealing with a habitual criminal? It's when we do exactly what you did. We get them doing the chicken dance. And if they don't lose their composure, that's what we want. We want them to feel like you mess with this. You've come across one of the masters, they will kick your behind. So every once in a while we need to sting them, and the more we can surprise them with what we sting them with, the more effective it is. Hang on, I'll explain that when we come back. Randy Kelton, Blue Law Radio. Randy Kelton, Vet Pack, Blue Law Radio. We'll be right back.
Are you a foothead or a do-good? If so, you're one of the last bearers of some of Britain's oldest, most traditional names. I'm Dr. Catherine Albrecht, back to tell about some colorful last names that are going extinct after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Is your last name Miracle, Relish, or Tumbler? If so, you're one of the final folks to bear some of Britain's oldest surnames, dating back to the Domesday Book of 1086. The Guild of One-Name Studies, which investigates the origin and heritage of names, says hundreds of British surnames are nearly extinct. Those include Rowbree, an Old English term for a nearby hill, and Dogood, likely the nickname of a well-intentioned man, also Foothead, from the property near the foot of Spurnhead in Yorkshire. But if your surname is Bread or Spinster, well, the Guild would be shocked. You see, old chap, those names are presumed extinct. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. Yeah, we done I see tools of ingenuity.
Okay, we are back. Randy Kelton, Vet Pack, Blue Law Radio. And I have you have animal control. Do they state that there's a city ordinance forbidding roosters?
Yes.
Okay, I've got this. Are you ready to have some great fun?
Oh, I am. Big time.
The city has a pullet prejudice. They're prejudiced against toward pullets, and they're biased against roosters. This is a sexual discrimination suit. Does sexual discrimination only apply to human beings?
No.
But I suspect that if you file against this officer, and I'm going to suggest that the more minor the offense, the more profound it is in its effect. When the officer does what he always does, what he's trained to do, and then you land on him like a ton of bricks. You know, I just filed against my local Texas Ranger because he followed protocol. And I was in Tarrant County and called 911 and wanted them to send an officer out to arrest the two jail guards or the two deputies at the metal detector going into the courthouse. Well, why do you want me to arrest them? I want you to arrest them for following policy. You want us to arrest them for following policy? Yes, I do. Where the policy is in violation of law, they can choose to follow policy and keep their job, or they can choose to follow law and not have to explain themselves to a grand jury. It's their call. So you get them for something where they never expected it. This officer came out and made threats against you while prominently displaying a deadly weapon. That's going to be aggravated assault.
Yeah.
Technically, aggravated assault, and that's what you want. You don't want the guy who, like I had a bailiff order me out of the courthouse, and when I stepped out the door, he gave me a slight push on the back just as my foot hit a carpet that was laying there to clean your feet on, and it caused that carpet to come out from under me, and I fell backwards and landed on a granite step with my elbow and broke my elbow. He did not mean to do that. And he didn't give me a hard push at all.
Yeah, not malicious.
Yeah, no way I was going to ruin his career over that.
Yeah.
But I just filed against my district judge for first-degree felony aggravated assault because he had a bailiff touch me. I bet he didn't see that coming.
No.
That's the kind. Now, I do not want him indicted for that. And I told the prosecutor, I made my best argument for indictment, but I expect you to get in there and make sure that this judge does not get indicted. He said, you can be sure of that. But the judge is never going to forget over something he does all the time that he almost went to prison. Problem with grand juries is you never know what they're going to do. And if you can walk them into it, if you can ask them the right questions and then come back and hammer them because of their answers, they're going to say, that SOB set me up. And you ask him the right questions. Now you go back and charge him with first-degree felony aggravated assault. Or in I don't know what it will be in Oklahoma. It'll definitely be aggravated assault. He's going to think, he set me up for that. He walked me right into it. And that's what will terrify them.
Yeah.
You got this animal control officer here. He watches you do this to the cop, and he's thinking, holy crap, I called this guy out here to take advantage of his authority, and this guy is working him over. The animal control guy is not going to want anything to do with you.
Yeah. No, do I go also after the animal control?
Absolutely. But, okay, you got to look at, I would need to see.
Citations.
I don't know. I'd have to examine this in more detail. Send me an email on this. We're kind of running low on time, and I got a bunch of callers. But I know you've been waiting quite a while, and I apologize for that. But send me an email on it. So kind of give me a synopsis of what occurred. And, I don't want to do the animal control officer any harm, but these kinds of things are great teaching tools for these public officials. We want to give them reason to be very careful of what they do. Was the animal control officer armed?
She was not.
Good. Wonderful. Wonderful. It's nice that the city don't have them armed. Okay. And you might, this might be a good argument to bring. It's all about money. So if you can bring an argument, looks like it's going to cost them money, good chance they'll go and leave you alone. But send me an email because I want to find out what your intended purpose is, what your outcome is, what you want to achieve, and then I can give you a better idea of how to move forward on this. Just email me, randy@ruleoflawradio.com.
Yeah. Well, I want to keep my property. That's what I want.
Are they trying to take your property?
Well, they're telling me I have to get rid of the rooster.
Oh, okay. You can give them such a fight, they won't believe it, and they won't ever want to mess with you again.
That's what I want. I want a taste of the fight. And
okay. Here's the problem you're going to have. Once you figure it out, and you're already getting an idea, once you figure out that you're the master, they're the servants, jerking them around and making them dance for you is going to get to be way too much fun.
Yeah.
Well, I have to be careful.
I'm very proud of myself.
Yeah, I have to be careful because I can get these guys to beat me into unconsciousness just by having too much fun at their expense.
Yeah.
Okay, send me an email and
okay.
So I can get into this in more detail.
And does it make any difference? I put it in brackets where they wanted me to sign the certificate, and I put it under duress, and then I signed it.
Oh, that's perfect. That's perfect because if it's under duress, it's not really signed.
Okay. I'll send you that email.
Okay. Send me an email and we'll go over this.
Okay.
Thank you. Okay. Now we're going to go to Rob in New Mexico who has some crowing to do.
Hey, Randy.
Okay. We were just talking about chicken bias, and now we get somebody that wants to crow.
Yeah, well, we talked about beating animal control up, too, because I did that 3 years ago. They won't bother me anymore.
That's generally how it works. Okay, what do you have going today?
Just a short, I'm going to keep it short. I won't give the whole background, but we had a motion for judgment on the pleadings and a motion for expedited hearing on possession of the property.
Okay, hold on. This is a case where Rob purchased a property, and he paid for insurance that the escrow agent never purchased. Okay, go ahead.
Well, the seller was supposed to purchase it, not the escrow agent, but the escrow agent refused to account for the money and won't give it back. Still won't give it back. So, anyway, I sued everybody. So the motion for judgment on the pleadings was by the broker seeking to be excused from fraud, theft, breach of fiduciary duty, and Unfair Practices Act. Well, the fraud, theft, and breach of fiduciary duty claims weren't against him anyway, but I argued them just for fun. And the judge gave him that, and then the attorney tried to argue that the Unfair Practices Act didn't apply because it doesn't apply to sale of real property. Well, I pointed out that the claim wasn't on the sale of real property. It was on a service relating to the sale. And the opposing counsel argued and huffed and puffed, and the judge is about to shoot him. The judge was not impressed with his argument, ruled in my favor on that one.
So you get to keep the claim.
Keep the Unfair Practice Act. And he's going to break.
Okay.
Easy.
Okay, we are back. Randy Kelton, News Law Radio. So you won one, Rob.
I won two. The second one was the motion for possession. And the property or make me pay for all the time I've been there and all the time forward, until I'm gone. And I argued against that. Had a pretty good argument. Basically, my argument ultimately came down to their motion was a motion for judgment that didn't meet any requirements. Judgment. And the judge said that he was not going to put us out of the property and give them possession at this time, but that it was not proper for us to be living there without paying. So he's setting up an account with the court that we have to pay every month, and then whoever wins the case ultimately will get part or all of that. They hemmed and hawed about that and said that they needed to be in possession of the property and that this was an urgent matter. And the judge said, this started last February. You did nothing about it. You did nothing about it until he sued you in December. And now in April, you're going to try and claim this as urgent? I don't see any sense of urgency here. He was not pleased with their argument either.
This is good. You got a judge with a pro se on one side and is actually ruling in what appears to be a fair manner. This is good news.
Well, I suspect the sellers, I told you before, the sellers on this place are very reputable. Every time we tell anybody that we're having problems, they're like, oh, you bought from so-and-so, didn't you? And we're like, yeah.
Oh, so they're well known. They may have screwed the judge or one of the judge's relatives, so now they're getting paid back.
I think he might be using me as a tool to bring them down.
Wonderful.
So let's okay. Now, real quick, I got a Rule 68 offer for judgment in my FDCPA case in federal court. Can I respond to that with a conditional acceptance?
Okay, say that you have what kind of offer for a judgment?
Rule 68, that's where they say, yeah, we did it. Here, we'll give you this much. If you don't take it and you win, but you don't get this much, you don't get more than this much money, you're liable for our additional attorney fees.
Horse poop. Who said that? The judge or the other side?
This is the debt collector attorney, and that is actually what Rule 68 says. If I win, but I don't get more than what they offer, then I can be liable for all of their attorney's fees going forward from the offer.
Okay, and that's reasonable.
I could have ended it. Yeah, because I could have ended it there, got that much. But the problem is they're only offering me $1,001. Okay,
then what would you expect? You make a counteroffer. This is just negotiation.
Right. That's what I was going to say. I was going to say conditional acceptance of $1,000 plus costs. Costs are the harm that the debt collector attorney caused me. So he makes me whole on that, and I'll take their $1,000 and drop it.
Yeah, give them a counteroffer, and then it puts the onus back on them because they're in the same position.
Now, I did lose a hearing on the second escrow company, who I now have in federal court on FTC.
Wait a minute. We've only got a few minutes left, so I don't want to go through every permutation.
Okay, never mind. I'll let you go. Grab the next one.
Okay, thank you, Rob. You did good for a truck driver.
Not bad.
Okay, thank you. Okay, now we're going to go to Truth Raider in Oregon. Hello, Truth. Or is that Raider?
Randy. Both of them. Rand?
Okay, Traitor.
No. That's not patriotic.
Okay, what do you have for us today?
Well, I tell you what, trying to get these cases all taken care of, man, I feel like a one-legged cat trying to bury turds on a frozen pond. You know what I mean?
I'm going to try not to build that image in my brain because I'll never get it scratched off the back of my eyeballs.
Anyway, making progress here. So let's, we've got about 6 or 7 minutes to go here. Well, let's get with it then. Make the long story short, I'm up to 5 tickets now, traffic tickets. I'm having trouble getting communication back and forth with Eddie. I got some questions here. But I'll pass this question to you. That's the most important thing. I got a lot of other things to talk about, but let's get on to the most important thing here. I'm trying to use a U.S. Supreme Court ruling. And if you want me to, I can read it to you what it is. But it's Thompson versus Smith, in case you don't know what that is.
No, I'm not familiar with it.
Okay. The U.S. Supreme Court ruled that anyone with an automobile has the unalienable right, the natural right to travel upon the roads, highways, and commonways for normal use without a license, registration, or proof of insurance.
Okay, hang on. What year was that?
That's what I don't know exactly on it. It has the subsections on it. It's also in jurisdictionary. It's in a certain passage of page 1135, I think, something like that, in some American jurisdictionary. I'd have to grab the piece of paper and read it to you real quick so that way you can reference it yourself. But, yeah, I found this, and it was at my library. Grab the paper. See this real quick. Anyway, yeah, while I'm grabbing that paper, what do you think about this one? I got pulled over yesterday by a local municipality unit. It was just a little Dodge Charger with just simple, the regular license plates you get from the DMV for just regular people, just a regular commercial citizen's plate instead of the official government plate that's supposed to be on the unit. And I got traffic stopped. Is that a violation?
Okay, wait a minute.
Pull me over, unmarked unit, a traffic stop, unmarked unit with just regular state plates, just a regular commercial, public plates that you'd have on anybody's automobile. Is that illegal for him to do that?
Not that I know of, so long as he is actually a certified peace officer.
Okay. Yeah, he was.
Okay. I know of no statutory requirement that they be marked, because we certainly have unmarked cars, or supposedly unmarked, but everybody recognizes them.
Some states do and some states don't. I've seen a few things on YouTube that, for example, in the state of Washington, it was against some type of code. If they can conduct traffic stops, they must conduct them in marked units.
Okay, and that is likely. Oh, wait a minute. Okay, this is a traffic stop. When you said that, I'm thinking a peace officer driving home in his personal vehicle observes a crime. He can act to intervene.
Yeah.
But if it's a Class C misdemeanor, then it's very likely that there would be certain restrictions on what he can do.
Okay.
Because if there's not restrictions on that, you get a cop that's had a hard day and he's tired and he's grumpy and somebody cuts him off, and the cop pulls him over and abuses his discretion. I would expect there to be statutory limitations, but the limitations would have to be statutory.
Okay. Very good. All right. We're running out of time here. So let me have a chance to read this to everybody out there listening in Rule of Law Radio land. This is the U.S. Supreme Court says no license necessary to drive or travel an automobile on public highways or streets. The U.S. Supreme Court and other high court citations proving that no license necessary for normal use of an automobile on common ways. In quotations here, the right of a citizen to travel upon the public highways and to transport his or her property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege with which may be permitted or prohibited at will, but a common right which he or she has under his or her right to life, liberty, and the pursuit of happiness. Under the constitutional guarantee, one inclination along with the public highways or in public highways or places, and while conducting his or her self in an orderly and decent manner, neither interfering nor disturbing another's rights, he or she will be protected not only in his or her person, but in his or her safe conduct,
Okay. My producer tells me that's not. I heard Compton. He tells me it's Thompson v. Smith.
Yeah, Thompson versus Smith.
Okay, 154 Southeast 579.
Correct.
Perfect.
11 American jurisprudence. Constitutional law, section 329, page 1135.
Okay, if you can find me more case law on this, I will write a pleading that we can file with the court, and it places the law before the court. Once the law is before the court must exercise its duty to determine the facts in accordance with the rules of evidence and apply the law as it comes to him to the facts in the case. If he doesn't, we get to sting him good.
Yes.
So that's great. I've heard this quotation before, but I didn't know exactly where it came from.
Right. Well, I wanted to have a chance to see what Eddie's take on that is, and he doesn't quite understand. It's kind of vague to him. He doesn't understand what I want to use it for.
He probably knows that citation because that sounds like something I've heard from Eddie. But I'm sorry, we are completely out of time. And I'm sorry I got you on so late. Next time, call in earlier. I'd like to bring you up sooner. We've had a great show tonight. We've had all knowledgeable callers. This was a wonderful show. Thank you guys for helping make a wonderful show for me. I appreciate that. I am pleased tonight. Thank you all. We'll be back next week. Good night.